Welcome to Inside IR, a podcast series by Herbert Smith Freehills that explores the latest developments in the Australian industrial relations landscape.
Hello and welcome to Inside IR, the Australian Industrial Relations podcast, the series that arms HR, IR and legal professionals with the latest industrial relations thinking. My name is Rohan Doyle. I'm a partner in the Herbert Smith Freehills Industrial Relations team, and I'm joined today by some seasoned, very experienced professionals on the Inside IR panel, partners Natalie Gaspar and Nicholas Ogilvie. Welcome, Nick and Nat.
Thanks, Rohan. Good to be invited back.
Yeah, good to be back. Does that mean I'm old? Is that how it works?
No, seasoned and experienced.
Okay, right. I'll remember that.
But you have had a bit of a hiatus from Inside IR.
Yeah, had a break.
What have you been up to during that time, Nick?
Studying legislation, basically. Making sure I'm up to speed. So.
Oh, that's good to hear.
278 pages of the new bill. So.
What about yourself, Nat?
Yeah, likewise, helping clients get across these changes and the reforms that have already come into place. So there's a bit happening in our space, which is fantastic.
There certainly is, and it has been quite a busy period over the last few months. I mean, we're still dealing with the implications of the last bill, the Secure Jobs Better Pay bill, which commenced last December. And there's a bit going on in the IR space, to say the least. We do have a new bill, Nico, you're right. It is 278 pages plus contents page. And it has 28 distinct parts. It's called the Closing Loopholes Bill. We'll leave the title out of the discussion today, but it does propose reforms that will have a substantial impact on industrial relations in this country, and I think I'd make a case to say that it's probably going to have a bigger impact than the Secure Jobs Better Pay legislation. So a continuation of the biggest change to industrial relations regulation probably ever.
Yeah, I think that's right, Rohan. I think it's important for our listeners and viewers to keep in mind that you look at this piece of legislation in the context of the legislative reforms that have already taken effect. And, you know, as we know, unapologetically, unashamedly, what this suite and package of reforms is designed to do is increase the real wages of Australians. And, you know, this is the second hit of it. And I think, you know, as we'll get into a bit more detail, that's probably going to meet its goal.
Yep, that's right, Nat. And I mean, what can you tell us about the passage of the bill? What comes next?
Yeah, so look, obviously the government was quite keen to move this through this side of Christmas, but shortly after the introduction of the bill into the House, the Senate announced that it would be referred to the Senate committee for a report back by the 1st of February. So we do have some time, but it's not a great deal of time, Rohan and Nick. So for people to get across the vast volume of legislation and start thinking about what these reforms will mean to their business. So I think obviously nothing will happen in terms of legislative effect before February this year. One of the other, I think, important things to keep in mind is that most of the reforms are stated to take effect upon royal assent. So people do need to move quite quickly. Some of the changes, there is a little bit more lead time, but this is one that, whilst there is a short grace period, I think we can anticipate that most of the changes will go through, and we need to get ready.
Just on that too, the one thing that happens already is the anti-avoidance provisions, which we'll get to in the next part, but they commence now, basically. Yeah. So you need to plan ahead.
You're right. You make a good point about time, and anti-avoidance means you kind of need to be acting differently now, just in case it does pass. But there is staggered commencement for some provisions. We have, I think, 1 July 2024 for some, 1 November 2024 for others, and January 2025 for others again. But to give an example as to why there's going to be a lot of time pressure in this, same job, same pay, orders can't take effect until November 2024, but applications can be made from royal assent. And so there will be a real mad flurry of activity the minute that these changes pass, if they do pass, of course. So preparation is essential. So what's in the bill? That's the big question. Now, we're not going to cover it all today because there's just too much, but being the leading IR firm in the country, we've published what I think is the most comprehensive and helpful summary of the bill in the market, which you can access on our Industrial Relations Reform Hub. Simply Google Herbert Smith Freehills and Closing Loopholes. It's got a bit of a ring to it. And that will pop up on your Google or other search engine search and be within reach. Here it is for those looking for it. Given that summary, we're not going to go through every change in detail, but just to set the framework for this discussion, the way I look at it is that there are 14 main changes in the legislation, 7 big ticket, 7 minor. The big ticket items, again, just to set the scene, are 1, a new casual employee definition and associated conversion processes. 2, a new definition for working out whether a worker is an employee or contractor. 3, same job, same pay orders, albeit renamed. We'll come to that later, Nico. 4, new workplace delegate rights. 5, new minimum conditions and rights for non-employees in the gig economy and road transport distribution. 6, a new Fair Work Commission jurisdiction in relation to unfair contracts. And 7, a new federal criminal offence for wage theft, including some associated increases in penalties and related compliance changes. So they're what I've been describing as the big 7, the 7 big ticket items. The 7 additional minor items you can read in our summary. But those 7 big ticket changes are going to put a stake in the ground on this, and people might have already seen my LinkedIn post to similar effect. But these changes are going to increase compliance costs for business. It's an incredibly complex bill, and if you flick through those 7 big ticket items, multi-factor tests are all over the place. Is the worker a casual or a permanent employee? Yeah. Multi-factor test. Is the worker a employee or contractor? Multi-factor. Yeah. Should a same job, same pay order be made? Multi-factor test.
Not just multi-factor, but multi-factor plus anything else the Commission wants to take into consideration. So
that's right. Yeah, one of the multi-factors is that. Yes. Yeah, and so this is an issue because you need to actually understand what the likely outcome is of all these tests before you can actually determine what the compliance minimums are for your business. Now, that's an extraordinarily difficult task. So unfortunately, compliance costs are going to go through the roof. What will also happen is we're going to be spending more and more time in the Commission because a lot of these changes involve new Fair Work Commission jurisdiction to set minimum conditions of employment or engagement. Same job, same pay orders. Minimum conditions, which we'll come to in the gig economy and in road transport distribution, conversion disputes for casuals, so on and so forth. And on top of all of that, I think unions are also now if there was any doubt, firmly back in the centre of the IR system by virtue of some new rights that are being given to help them with grassroots organising. So all of those things collectively, it's impossible in my mind to see anything other than labour costs escalating quite significantly.
And a degree of disputation in relation to all those aspects as well. So not only is the Commission empowered to grant orders in relation to those things, but resolve disputes in relation to those things. And reasonable minds may differ on that menu of multi-factor tests that you indicated.
Absolutely.
So we're back to the future where there's all these indicia of employment and a layer of subjectivity and discretion in relation to those things. And I plead the case that the whole purpose of this regulation is to help employers and workers understand what their rights and obligations are. And I'm just worried we've taken a bit of a step back as a country in relation to that aspect.
Yeah. Look, we'll come back to the bigger picture on all of this, how the reforms interact, what the objective is in later episodes of Inside IR. But what is important is that employers and principals aren't just mere passengers in the implementation of this new legislation. There are going to be cases that need to be run to help set new minimum conditions. And if employers, principals don't engage with that process, it's essentially writing a blank cheque. It's going to be a very expensive process. So that will require engagement, will require preparation. We're going to do what we can to try and arm you for those processes, including the topics that we'll cover today. But as I mentioned, it's going to take a few episodes of Inside IR to get across those 7 big ticket items. Today, we're going to focus on 2 of what are arguably the biggest of the 7. 1 being the new same job, same pay orders and jurisdiction, and 2 being the new minimum rights and conditions for non-employees in the gig economy and road transport contractor space. So without further ado, Nico, same job, same pay. What can you tell us about that, including the name change?
Well, that's right. It's not same job, same pay. You won't find that anywhere in the legislation. It's closing the labour hire loopholes or regulated labour hire arrangement orders is basically how it's referred to. So for some reason...
Far less catchy.
It's a lot harder to write out, but for some reason the bill's moved away from that language, which was even some sort of in the previous proposals, it was really around same job, same pay, but that's been moved away from completely. To really simplify it, you're right, it's not one of these additional jurisdictions that the Commission's been given, and a wide range of powers, and it's got these indicia tests as part of it. But essentially it is a provision that allows the Commission to make an order which covers which will apply to employees of labour hire employees where they're providing their labour to another employee, to a host. Now, where the host has an instrument in place, and the instrument would cover those labour hire employees if they're performing the work directly for the host, then it gives an entitlement to those labour hire employees to be paid no less than what's called a protected rate of pay. So no less than a protected rate of pay, which is what would be applied under that instrument to the to the host employees if it was directly applied. So it's basically setting a minimum safety net for employees in relation to pay. It doesn't override the existing enterprise agreements that are in place. So you might have a labour hire employee who has his own EBA that has more beneficial conditions. As long what this does just sets like a higher bar, higher minimum test for them.
Yeah. What struck me in reading that though, Nico, is that unlike the legislation we saw in November 2021 on this same topic, it's not automatic. It requires an application to the Commission, requires an order. That is a positive. I mean, that delivers a bit of certainty. But it does raise the question about, well, what are the preconditions for the making of that order? Are you able to talk through that process, Nico?
I mean, the other point, just before I get to the other point, is that the structure of these arrangements doesn't matter. So the way in which the labour is provided or the corporate structures don't matter. It's not relevant whether or not it's an internal corporate arrangement between the same group companies. That's all not relevant for the purposes. And it also doesn't matter whether the classifications or the categories are not covered by the agreement. Provided the labour is being provided by the labour hire employer, you can apply for the order. So, and you're right, it's by application. So the application can be made by a union, can be made by employees of the host, it can be made by employees of the labour hire provider. So there's a range of different people that can make the application to the Commission. Really what you need is, it needs employer, not a small business, so there's exemptions for small business, and it supplies labour to supplies its employees to another business to perform work. That business has an instrument, what's called an industrial instrument, so it's not just enterprise agreements, but broadly trying to capture a whole range of awards and other instruments, Commonwealth public sector, things that operate in the same way collectively as enterprise agreements, so they apply. And then that instrument would need to be able to establish that instrument would, if it was to apply to the labour hire employees, and they're performing the same kind of work or substantially the same kind of work, then the order can be made, provided that it's reasonable to the Commission. And as you said, there's a range of factors that get taken into account, some of which are interesting because they fall one way or the other, but they don't tell you which way they should fall. So one, for example, is that the Commission needs to consider whether or not there's a contract for the provision of service, so not really labour hire, but a service contract, and then take that into account. Now, that's not an exception, that's just a thing that the Commission must take into account. So just because it's a contract for service doesn't mean it's outside the regime. It might be in it, just needs to be considered by the Commission. In terms of the same kind of substantial, same kind of work, we're not clear on what that means. We can assume, given the way the legislation is written, it's going to be quite broad. We've seen those words before. If you look at the transfer of business provisions, which are in the Act currently, talk about the same or substantially same kind of work. So, but there hasn't been a lot of jurisdiction dealing with those sort of cases because they either tend not to be contested or not contested on those grounds. So there's going to be a lot of pressure to work out what's the same or same kind of work. But I think we can safely assume it's going to be broad. So it's going to take a very, very generous interpretation of those provisions.
I'm keen to zero in on that threshold test, Nico. Before we get to what an order does, what are the implications of it, the test for the making of the order, because I know we're using sort of shorthand, using the reference to labour hire employers, but it's not expressed that way in terms of the substance of the bill, is it? No. And it's focused on, I'll just read the words, where an employer supplies or will supply directly or indirectly one or more employees to a regulated host.
Yep.
That's one of the first prerequisites. Now, as you said, that's quite broad. I mean, directly or indirectly.
Yep.
Legislation makes it clear there doesn't even need to be a direct contractual engagement between those entities.
That doesn't have to be direct, that's right.
So I think the first warning from us is don't just assume this applies to traditional labour hire. It doesn't. And to your point, they could have had an express exclusion of service contractors if they wanted in legislation. They haven't done that. Merely a factor which suggests you could have orders that apply to service contract arrangements.
That's right.
Yeah, but I'm also interested, we're getting a lot of questions around the relevance of let's call it the enterprise agreement test. I know there are some other instruments that are in play in this definition, but the extent to which there needs to be an enterprise agreement that covers the work within the regulated host, the host employer. Now that's a precondition in itself, isn't it?
That's right.
If there's no enterprise agreement that covers the regulated host in respect of the work, then no order can be made.
And that the EM talks about ensuring that the bargain terms and conditions from the host are not diluted by labour hire employees having lower terms and conditions when they're performing the same kind of work. So that's what it's really directed at. So preserving that, and it's a real move away from when we've had enterprise bargaining at the enterprise level since the late 90s, whereas there was a move in the pre-Fair Work Act to really focus on negotiation and bargaining between employers and employees at the enterprise level. What this does is moves away from that in conjunction with the multi-enterprise bargaining system as well. You're really moving to much more collective where it's not about the employer and the employees directly, but others that are engaged as well.
Yeah.
And I think the scenario that you just described, Rohan, where there's not an enterprise agreement at the workplace that would apply, the solution for workers in that is the multi-enterprise bargaining stream, of course, which is a feature of the legislation that we currently have in place. So
all of this interacts quite neatly.
There is an air of collectivism. In fact, it's more than an air. This is about collective bargain terms and conditions up and down the supply chain, regardless of employing entity, where the work performed is comparable or the same. And we'll come to that when we talk about the road transport sector and gig economy participants as well.
Exactly. Well, let's imagine, Nico. So it's been established, an application's been made to the Commission.
Yep.
It's been established that there is an employer who supplies directly or indirectly one or more of their employees to a host.
Yep.
That host has an enterprise agreement that if they'd employed this person directly would cover the work.
Yep.
They've ticked all those boxes. They're not a small business employer. It's not in relation to a training arrangement, which is also excluded. It's not a short-term arrangement, which we'll come to in a minute. The order's made. What does that mean? What happens?
So the effect of the orders made is that order's binding on the labour hire, what we'll call the labour hire employer and their employees. And that creates what, as I said, is a protected rate of pay. So the obligation on the labour hire employer is to pay their employees who are performing that work of the same kind the protected rate of pay, which is defined as the full rate of pay that would apply if they were covered by the instrument going forward.
Under the host enterprise
Under the host enterprise agreement. So there's also another regime, as part of the provisions, there's also an ability to the Commission to make an order for an alternative protected rate of pay, which, for example, if there was another entity in the group or there's other instruments that apply to related parties, the Commission can look at those instruments and apply that as a protected rate of pay. So it's broader than just, you have a system where there's just the direct host enterprise agreement. There can be other enterprise agreements that get taken into account as well. So it's quite expansive. So any of the sort of structural, I don't like to talk about loopholes, it's about opportunities, but any of the structural opportunities available to look at other entities, that gets ruled out as well.
Yeah, and that's an area that's causing a lot of confusion. Getting lots of questions around that.
Yep.
This alternative protected rate of pay where you can go, let's call it enterprise agreement shopping and pick the one that's most favourable.
Yep.
There's still, before you can actually get to that, there still necessarily needs to be that first precondition satisfied. Right. And that is, there still needs to be an EA that would otherwise cover the work if the host were to engage the employer to perform that work.
Because it's at two levels. So you've got a regulated labour hire arrangement order being made, and then from that becomes either protected rate of pay or some alternative protected rate of pay, which then is imposed on the labour hire employees.
I'm interested in the defence that you mentioned, Nico. We haven't sort of gone into detail on that yet. There's defence as to whether it's fair and reasonable to make the order.
That's right. So part of the list of indicia is that the Commission needs to be satisfied and needs to be fair and reasonable to make the order. So that, again, we understand what fair and reasonable is, but there'll be differing views. So, and there's a whole range of factors in the legislation that gets taken into account in terms of the history of the injustice that applied, the type of work being performed, the nature of the relationship between the parties. And then, as I said, any other factor the Commission considers relevant to take into account. So, but the Commission needs to, as a threshold, needs to be satisfied it's fair and reasonable to apply to put in place an order and to apply the protected rate of pay.
Yeah, and that is one saving grace in this because there are going to be opportunities for certain employers and hosts to look at that test They might do the analysis and work out that otherwise they meet all the criteria. There's an EA, it's in respect of substantially the same work, etc.
Yeah.
But there still might be a basis on which to argue that it wouldn't be fair and reasonable for everyone to have to uplift rates to this highest common denominator. There might be good reasons as to why that's not fair and appropriate. It might be actually, albeit covered by the enterprise agreement, it might be different work than what employees are otherwise doing with the host and being remunerated at a higher rate for. There might be some historical reason as to why this is happening. There might be operational needs that need to be met. I mean, this is where the preparation comes in.
Yeah, I think that's right. And for those listening, engaging with your commercial and procurement colleagues, because this is really, the reality is that the nature by which these services are engaged by and provided by the host employer and received by the labour hire provider, there's commercial contract terms that regulate the basis upon which that labour and those is provided. So this will really require
some amendment.
Correct. This is the point. So this needs to be square. This is not a pure sort of IR issue. It really requires people to engage within the business to understand what this looks like.
Yeah.
Spot on that. Now, let's assume the order's made.
Yep.
I imagine there's going to be lots of questions or uncertainty between the host and the employer of the employees as to what the actual protected rate of pay is.
Yep.
Are there mechanisms in the Act to deal with that?
Yeah,
Nico?
so primarily it's an obligation on the host to provide information. So, and the Act, the provisions talk about a wide range of information, basically to enable the labour hire employer to work out what that protected rate of pay is. Now, it might be historically the way they've calculated it, it may be payroll records. It's quite broad, but I suppose the key for that is that there's a right to request that information, but the turnaround time must be, it's pretty quick. It's as soon as reasonably practical to provide that information. So it's got to be the obligation is to provide that to the labour hire employer quickly or as soon as reasonably possible.
You know what worries me about that? That it's going to be a defence to non-compliance with the order if the employer relies on incorrect information from the host about how to calculate it. What does that tell you? It tells you you're going to get a stack of questions for information from employers to hosts.
Yeah.
So that's going to create an industry in itself and something that's going to have to be managed. Short-term exception, Nico. There's another exclusion from all of this.
Yeah, so I mean, just the commentary around this is that it wasn't intended to deal with legitimate short-term labour hire requirements for an employer. So there's built-in, and once the order is made, there's potentially an exemption from applying the protected rate of pay for a short term, which is up to 3 months for some order being made. 3 months is not a long time, and we're hearing from some employers in industries that 3 months is just not workable in their industry because of the way that, and it talks about short-term or seasonal work. So what does seasonal work mean? How broad is that? We all understand, in the agriculture, horticultural sector, seasonal means fruit pickers are coming in and out. That's a simple example, but there are other broader applications for that seasonal work. That's
footy team.
That's right, football teams. There's other examples where people come and work over summer or work over winter, for example. But it's not necessarily aligned to the seasons. It's aligned to sort of periods of time. So that really needs to be explored. Yeah. And there's also an exemption for training arrangements. So putting in place an arrangement for training for a short period of time you get an exemption as well.
Yeah, and there's opportunities in exceptional circumstances to either reduce or increase that 3-month exception as well. But I imagine that will be applied in a pretty limited way. Which brings us, I think, to the final really significant element of this, Nico, and that's anti-avoidance.
So that's the sting in the tail for this. So as I said at the start, the anti-avoidance provisions take effect immediately. There are specific provisions that make avoidance contraventions. So basically, where an employer or host enters into a scheme or carries out or begins to carry out a scheme, either alone or with another person, where the sole or dominant purpose, so we know those words, sole or dominant purpose, is to prevent the Commission from making a regulated labour hire arrangement order, and the Commission is prevented from making the order, it's a breach of the anti-avoidance provision. So anything you put in place which has the sole or dominant purpose to do that becomes a breach of the anti-avoidance provision. Now, again...
And if it passes, it applies to conduct now.
Now, correct.
Yep.
So any restructuring of your employment arrangements you're doing now could potentially breach the anti-avoidance provisions. The other part of it is that we've seen the burden of proof for a lot of civil remedy provisions is the balance of probabilities. This is it could reasonably be concluded.
Yeah.
So there's a whole range of things that might not be. We know what a sole or dominant purpose is. We've seen that as part of the general protections provisions, but it could reasonably be concluded as a really low threshold for proof. So that's going to be difficult to get around. So anything, again, trying to find new loopholes, not loopholes, but new opportunities becomes a lot harder because of those provisions being put in place.
That's right.
And there's significant civil remedy penalty provisions that apply to the anti-avoidance provisions. Again, you've got a broad scheme which will be applied generously with a whole range of factors that the Commission can take into account. And then on top of that, any sort of arrangements that attempt to be put in place to avoid it, which have the effect of the order not being made, becomes a civil remedy provision itself.
As well as abusing the short-term exception or terminating employees to engage them as independent contractors.
That's right. So there's a specific anti-avoidance. If you engage an independent contractor to avoid this provision, again, you're in contravention of the provisions.
Yeah, that's right. So look, there's a lot to take in there, Nick. I think, as we said, this is extremely complex. It's already confusing a lot of employers and principals out there. But I think if it does go through, we're necessarily going to see a reduction in the use of contractors and labour hire.
That's right.
It incentivises the onboarding of more direct labour. For those who don't, it's inevitably going to be more expensive. You'll have to pay the rates that you would otherwise pay your direct hire plus margin on top.
Correct.
That really disincentivises.
And you combine that with provisions for casuals, so engaging casual labour, provide that with the newer provisions about maximum fixed-term contracts. Multi-enterprise bargaining, it really pushes employers away from other type of employment arrangements. And like these changes, as I said, we had sort of enterprise bargaining at an enterprise level since the late 90s. Some of our clients would have significantly different arrangements if this was in place in the 2000s. And some of our clients wouldn't exist. Like there'd be different entities that have been set up as part of the system. Under this regime, you just wouldn't set up some of these organisations.
Yeah, or you can't do it.
That's right.
But to your point, multi-enterprise bargaining, what this does is actually bring enterprise bargaining generally back to the very centre of the IR system. Because either you're onboarding a significant proportion of your workforce that has previously been external, therefore EAs that cover much more people, bigger negotiations, bigger risk, harder to actually mitigate industrial action. Or if you don't do that, you maintain external workforces, well, the EAs are actually dictating how much they cost anyway.
Correct.
So it's actually time. I think there's a long list of things that we suggest employers and principals do to ready for this. I won't go into all of them. Give us a call if you want more detail. But I think the two, number one, get ready for this fair and reasonable test. Of course, assess your exposure to the jurisdictional prerequisites as a first step. But if you find yourselves to likely be within this new system, what are you going to say about whether it's fair or reasonable to require you to apply these higher rates of pay or for your labour hire or contractor personnel to be paid those higher rates? And then secondly, we're going to have to engage more directly with enterprise bargaining. It's not possible anymore to sidestep EAs or to minimise their significance because there's alternate labour that's being paid at different rates. We're going to have to engage with them, and if they don't work due to flexibility, cost, content, well, they're necessarily going to have to be negotiated down. And if you can't do that voluntarily, we do have the intractable bargaining jurisdiction to now look at workplace determinations.
That's right. And we've seen a couple of applications be made as we're recording this today, so it'll be really interesting to see how that plays out. But the ability of employers to rely upon contingent labour sources, whether that be casual flexing up in the manner that we have or alternate labour sources in the form of contractors. The other point, Rohan, which you've touched on, but it really means that the ability for employers to mitigate protected industrial action and continue operations is really diminished in that space. And again, the intractable bargaining stream will be a really important mechanism, I think, in all this.
Yeah, many people behind us working on that as we speak.
Yeah,
I think
that's right.
Anyway, thanks very much, Nico. A lot to think about there. We'll launch straight into our second topic, Nat, the regulation of non-employees in the gig economy and road transport.
Thanks, Rohan. Look, I think this is a really profound move by this country to regulate a whole suite of workers that previously haven't had the sort of protection. So at a really high level, you know, we've got and had for such a long time the common law cases dealing with concepts of, you know, master servant and no work, no pay and protections given to employees. that distinction, employees, once they have that status, have a whole suite of rights and protections, ranging from protection from unfair dismissal, the ability to engage in collective bargaining, leave entitlements, those sorts of things. And with a few legislative exceptions in the form of, say, some workers' compensation protection and superannuation entitlements, it's been a case of quite all or nothing. And the rationale for that is that if you're an independent contractor, the focus is on those two words. The independent, so you negotiate the terms and conditions that suits you for the provision of those services. And the contract, it's a recognition of the privity of contract and the rights for parties to be able to bargain and, sell their labour and their skills in that particular manner. Now, if passed, what we are moving to as a country is some form of protections, employee-like protections for employee-like workers that are not employees. And so we've seen this already in some jurisdictions like Canada. There is a concept of dependent worker. In the UK, we're seeing similar sorts of things. These suites of reforms go further than that though. So in those countries, there are protections against things like unfair dismissal, basically, and minimum terms and conditions, and it's an individualised protection. What is being proposed now is, and I'll talk about this in a bit more detail, again, collectivism, a push from government and a recognition that there is strength in numbers. So not only do you, Nico, as an individual, get protections from the right to not be removed from your online platform in an unfair manner or without a valid reason or having a chance to convince me why that shouldn't be the case, but you, Nick, and you, Rohan, can band together and come to me with the assistance of your union and demand terms and conditions of employment that apply across you. So just at the outset, really, really profound changes.
It's big, that's for sure.
It is. It's really, again, to your point, the Commission is going to be very busy indeed. And a lot of the detail as to those terms and conditions and the right, that Commission is going to be provided with enhanced powers and jurisdiction to not only set the terms and conditions of those employment, but deal with quasi-employment, employment-like terms and conditions, but also resolve disputes in relation to those things.
Before we get to those details now, I'm interested in, so the group of workers that this applies to is not at large, there's no sort of general test, it's sort of two discrete groups.
Yep,
two discrete groups.
Yeah, sure, absolutely. Yeah. So there are participants in the gig economy, and it's not just anyone who utilises an online platform to provide their services. This is really targeted towards those who are wholly or effectively fully dependent upon that labour source in order to provide their services. There's a recognition that those people have low bargaining power. So again, a degree of subjectivity in that test in relation to who would be considered to be an eligible or regulated employee-like participant in that space.
So what are the examples?
Without naming names. We don't want to mention a client or potential client.
Those who provide specialised services where I think they have a greater preparedness or ability to engage the terms and conditions, negotiate terms and conditions, and those who, for example, don't have those specialised skills and might jump in a vehicle or on a bike to deliver goods from A to B.
One example we've seen in the press, right, is let's call it the sort of air tasker type arrangement where you have, in large part, trades, and I'm generalising, but you've got tradespeople who put out some advertisement through Airtasker and say I'm available to perform X, Y, Z services. They've got their own business.
I'll mow your lawn for $200.
Yeah. Now it's open for them to set the rate. Generally speaking, how to do it. The cost includes provision of materials and all those things. I mean that pretty unlikely to be captured by this.
Correct. It's not, and quite specifically, it's not designed to capture that. And so. To build on your point, exactly, those people, or even higher specialised services where there is the ability to negotiate terms and conditions. But participants who participate on platforms where basically the terms and conditions by which they are paid is dictated by that online platform. It is designed to capture them because the bargaining power is not there. There's also a threshold test in terms of length of engagement and participation in that platform. So again, not dissimilar to our minimum engagement period for an eligible worker to bring an unfair dismissal claim, the 6 months there. The other area of focus of regulated workers is in relation to the road transport and distribution industry and up and down the supply chain. So traditionally in that industry, you have a category of workers who are owner drivers, to use that sort of language, who will often provide their own vehicle for a transport operator to provide their services. The legislation will extend up and down the supply chain of those drivers, independent contractors, and the road transport operator.
There's been state-based legislation.
There has,
contracts
absolutely, that's right, Nico. So in New South Wales, it is an area that's already, regulated, and even more broadly, the Federal Independent Contractors Act regulates the fairness of contracts in relation to these sorts of services. So this is being brought into the federal scheme under the Fair Work Act, and as we said, a whole host of powers in relation to that.
So they're the two groups.
Yep.
Digital labour's platform operators and road transport distribution contractors.
Yep.
What happens then? So let's assume we're dealing with those cohorts. What's the effect of this regulation?
So one of the main changes is that the Fair Work Commission will have the power to make a minimum standards order. And an MSO is like you will hear in relation to a modern award. So the idea of an MSO is to set the minimum conditions of employment, not necessarily the terms, and I keep saying employment. Engagement or quasi-employment in relation to the provision of work in these sectors. One takeaway for those listening who might be brought into this sphere is that it is absolutely critical to participate in the consultation process for the making of those instruments. Now, the breadth of matters that the Fair Work Commission can include in an MSO are reasonably broad, not as broad as the range of matters that are capable of being included in a modern award. But guys,
not far off though.
No, it's not far off. And one of them I was struck by is that an MSO can include terms including but not related to payment terms. Okay, fair enough. That's be paid fortnightly or those sorts of things. Deductions, working time. For people who jump on an online platform and choose to deliver a pizza at a time that suits them around their uni break or whatever it is that they're doing.
Someone's hungry.
How bizarre. There is just, it's going to be really interesting to see how this is tackled by the Commission, because we do have a suite of modern awards and, road transport and distribution award, we've got the fast forward industry award, we've got a suite of terms and conditions of employment, but working time, it might be that there's a limitation on people accessing that particular platform for more than 12 hours at a time, for example. But what we do know about participants in those digital platforms is that they platform jump, right? So
that's the big question, all of this, Nat, because what it does is give a lot of scope for discretion. And this process could end anywhere, because that could be interpreted narrowly, and maybe it's a fatigue-based rule that will be imposed that's actually quite limited in its application.
Maybe.
Or it could be at the other end of the spectrum.
Yeah.
So your suggestion is a good one, that you can't be a passenger in this.
Absolutely not,
If
so
you're
to
affected
speak.
by
Yeah.
it. That's actually quite clear. I wish that was
Well
deliberate.
done.
That's nice. But make submissions is your point.
Make submissions, and the other thing to keep in mind is that these workers have the ability to be represented by unions who, in this space. So it is going to be very similar to the process that we've all become accustomed with, those seasoned practitioners with the award simplification, the award modernisation process. It is going to be a similar sort of regime in the relation to the creation of MSOs in that space.
What else is there, Nat? MSOs? What else?
Collectivism, collective agreement. So this is the other really important point, again, that on top of what we have, like the baseline MSOs dealing with awards, there is also the ability for participants, so road transport owner-drivers or a collection of participants who provide their services through a digital platform to collectivise and to bargain collectively for terms and conditions of engagement, nearly caught myself again,
Good.
that will apply, thank you, will apply to people who are covered by that particular collective agreement.
And we haven't seen that in state-based legislation.
No,
So it's been individual.
no, we haven't.
There's been representation, but not the collectivism. So.
Absolutely. And again, this is something that distinguishes Australia from other common law jurisdictions where we have seen some form of dependent worker-like protections. But this goes a bit further, guys. So again, in relation to the process for how this works, there will be the ability to participate. There will be the Fair Work Commission is required to publish and consult in relation to those sorts of matters. So again, it's really critical to do some homework in relation to those things, and collective agreements are registered with the Fair Work Commission the way good old-fashioned enterprise agreements are in that space.
And the legislations, of course, had to include some carve-outs or exceptions from competition law as well to enable this to actually happen, which is quite fascinating.
Fascinating.
But so, and there's of course more detail on that in our summary, Nat. But one topic that's getting a lot of airplay is the unfair deactivation and termination jurisdiction. Can you tell us a bit?
Yeah, sure. So this again, you'll be familiar with some of the concepts. It is designed to provide workers, employee-like workers, subject to certain thresholds for eligibility. So time served, are they reliant on that? To have rights, remedies, if they have been unfairly deactivated from that platform. So basically, it provides rights and protections from deactivation where there's not a valid reason in relation to that deactivation, and basically procedural fairness type rights in relation to that as well. So players in that space, most of them already, by the way, have these sorts of mechanisms in place, but it does require for there to be some thought and process and robust procedures put in place as they would employees in relation to removing someone's access to a particular platform.
And then resourcing the applications that then ensue. I mean, I think that's the extra on top of this. As you say, many had these processes anyway, but there's necessarily going to be a heavy resourcing demand for dealing with it. And I imagine they'll need to hire some new Fair Work Commission members as well.
I think that's right, Rohan. Yeah.
And I think there was one other element to this, Nat, which we haven't touched on, the unfair contracts jurisdiction, which is actually a little bit broader, I think.
It is a bit broader. So again, this is designed to provide protection for contractors from unfair terms and conditions and bargaining power. So it touches over a little bit with the Independent Contracting Act at a federal level, and again, brings this into the Fair Work sphere where the Fair Work Commission will have jurisdiction to deal with terms that are unfair or in relation to contractors.
It's got a ring of the early 2000s New South Wales legislation for employees.
Correct. Correct.
Which isn't confined to gig economy or road transport. That's any parties to services contracts that earn below a certain threshold. So that's, again, more Fair Work Commission members, I suspect.
I think that's right.
Yeah. Okay. Look, that's been really useful, Nat. I think the implications of that are going to be huge. And again, it's going to probably cause a fairly significant shift in how these businesses engage labour, interact with labour, the cost of it. And I think it's really important that for those that participate in those sectors actually have a say in this process as the orders are made.
I think that's right, Rohan. I think the other point to keep in mind is that even if you're listening and you're going, we're fine because we don't operate a platform or we don't ourselves, operate a distribution of trucks, for example, at the end of the day, there is going to be increased cost arising from these changes, unapologetically. In fact, the Minister said, be prepared to pay more for your pizza. So this needs to come from somewhere. At the end of the day, it is going to be the end consumer who pays more to get whatever it is delivered to their home or to your business. So almost everyone listening, is going to have to get their products to their customers, B2B contracts. All this is going to place pressure on businesses in relation to the way they do business. And I think even if you're not participating directly in this, you need to have a keen eye to how people you contract with will be brought into this and what that will mean for your business and its operating costs.
That's well said, Nat. So look, that's all we have time for on this episode. We will have a couple more to dissect the remainder of the bill, but two really significant changes, if they commence, will have a substantive impact on most businesses. So keep an eye out for our updates. Have a look at our great summary that we've got available on our IR Reform Hub. And we also love to hear feedback on Inside IR. So please reach out, comment, direct message, send us an email, insideir@hsf.com. Otherwise, we look forward to you joining us on the next episode of Inside IR.